On the afternoon of Friday, the 26th of January 1996, at approximately 2:50 p.m., on a gravel access driveway leading to a small white frame house on a 800-acre private estate in Newtown Square, Pennsylvania, 23 miles west of central Philadelphia, a 1,995 Lincoln Town car pulled to a stop in front of an Olympic gold medal wrestler who was kneeling on the driveway repairing the radio of a parked vehicle. The driver of the Lincoln rolled down the driver's side window. The wrestler stood up and walked toward the car. The driver raised a Smith & Wesson .44 Magnum revolver, asked, "Do you have a problem with me?" and fired 3 rounds into the wrestler's chest and abdomen. The wrestler's name was David Schultz. He was 36 years old. He was the 1,984 Olympic gold medalist in freestyle wrestling at 74 kilograms. He was, at the moment of his death, 15 minutes later, the head coach of the United States freestyle wrestling team's primary Olympic training facility for the 1996 Atlanta Games, scheduled to open 6 months and 23 days after the afternoon of his murder. How does an American family that began with a single French émigré chemist setting up a gunpowder mill on the banks of the Brandywine Creek in 1802, the family that supplied half of the gunpowder used by the Union Army in the Civil War, that controlled the largest chemical company in the world, that owned at one point a controlling interest in General Motors, that produced nylon, neoprene, Kevlar, Lycra, Teflon, and the synthetic explosives used in the Manhattan Project end, after 194 years of unbroken commercial succession, with the founder's great-great-great-grandson firing 3 rounds from a revolver into an Olympic wrestler in a Pennsylvania driveway. The driver of the Lincoln was John du Pont. He was 57 years old. He was the great-great-grandson of Eleuthère Irénée du Pont de Nemours, the French chemist who had arrived at Newport, Rhode Island, on the 3rd of July 1799, with his father Pierre Samuel du Pont de Nemours, and a personal letter of introduction from Thomas Jefferson. He was the heir, by the trust instruments executed in his mother's will of 1,965, to approximately $200 million in DuPont and General Motors stock. He was the youngest of 4 children of William DuPont Jr. and Jean Lisiter Austin DuPont. He had been, since approximately 1976, a private benefactor of American Olympic-level amateur sport. In the next 40 minutes, you will learn 3 things the DuPont family has spent 30 years arranging the public record around. The exact contents of the trust instrument executed in May 1965 that, by its operative language, gave John du Pont, at age 26, with no demonstrated commercial responsibility, full discretionary control of approximately 1/8 of his mother's estate. The precise sequence of medical events between 1986 and 1996 inches, which 7 separate physicians, 3 psychologists, and 1 psychiatrist documented the deterioration of John DuPont's mental state without a single one of them succeeding in obtaining an involuntary commitment. And the exact 48 hours, between 2:50 p.m. on Friday, the 26th of January, 1996, and 2:43 p.m. on Sunday, the 28th of January, 1996, during which the heir of America's oldest industrial fortune barricaded himself inside the Foxcatcher mansion, while the Pennsylvania State Police negotiated his surrender by switching off the heat. This is not a story about a family that lost its money. The DuPonts did not lose their money. In 2026, the family's combined holdings exceed $16 billion across approximately 3,500 living lineal descendants of the founder. This is a story about what happens when a fortune produces a single, unaccountable heir. Hold one image in your mind. A red tracksuit, a Smith & Wesson, .44 Magnum revolver, blued steel, 6-inch barrel, a Lincoln Town car with the driver's side window rolled down in a Pennsylvania driveway on the afternoon of the 26th of January, 1996. Remember the tracksuit. We will return to it. In the autumn of 1791, a 20-year-old chemistry apprentice in Paris, the son of the celebrated economist and physiocrat Pierre Samuel du Pont de Nemours, raised in the intellectual milieu of pre-revolutionary French liberalism, was working in the laboratory of the Royal Powder Works at Esson, 20 miles south of the city. His master was Antoine Laurent Lavoisier. The chemist, who had 4 years earlier published the Traité élémentaire de chimie, the founding text of modern chemistry, and who held, by royal appointment of Louis XVI, the position of Régisseur des Poudres et Salpêtres, the chief administrator of the French national gunpowder monopoly. Lavoisier had taught the young apprentice, between 1788 and 1791, the precise procedural science of gunpowder manufacture. The controlled milling of saltpeter, charcoal, and sulfur in calibrated proportions, the granulation of the dried powder under hydraulic press, the storage and shipment protocols that prevented the catastrophic accidental detonation of finished product. The apprentice was Eleuthère Irénée du Pont de Nemours. In May 1794, during the Reign of Terror, Lavoisier was arrested by the Revolutionary Tribunal for his pre-revolutionary work as a tax collector. He was guillotined at the Place de la Révolution on the morning of the 8th of May 1794. The presiding judge, Jean-Baptiste Coffinhal, by the apocryphal but widely circulated account, replied to a petition for clemency on Lavoisier's behalf. La République n'a pas besoin de savants. The Republic has no need of scholars. Eleuthère's father, Pierre Samuel, was arrested on the same political grounds 3 months later, in July 1794. He was held in the Force prison in Paris awaiting his own trial when Robespierre fell on 9 Thermidor, the 27th of July 1794, and the terror ended. Pierre Samuel was released. The family had survived. They had also been politically and professionally destroyed in their own country. In October 1799, the du Pont family, Pierre Samuel, his 2 sons Victor and Eleuthère, their wives, and 7 grandchildren boarded the small American merchant ship, American Eagle, at the Ile de Ré, on the French Atlantic coast, and sailed for the United States. The crossing took 93 days, the longest documented Atlantic passage by an American merchant ship of the year. They arrived at Newport, Rhode Island, on the 1st of January 1800, carrying a personal letter of introduction from Thomas Jefferson, then the Vice President of the United States, addressed to the family's American business contacts. Eleuthère was 28 years old. He had spent the 93-day crossing thinking about gunpowder. What Eleuthère Irénée du Pont understood, by the time the American Eagle docked at Newport on the 1st of January 1800, was that the United States, a nation of approximately 5.25 million inhabitants, an active western frontier, and approximately 15,000 miles of unmapped Appalachian and trans-Mississippi wilderness, had no domestic manufacturer capable of producing gunpowder of consistent military or commercial grade. Every grain of black powder used in the United States in the year 1800 was either imported from England under Royal Crown licenses or manufactured by approximately a dozen small American operations whose product was, by Lavoisier's procedural standards, dangerously inconsistent in granulation and potency. He spent the first 18 months in America working as a translator and merchant in his father's New York City import-export firm. He used the time to systematically inspect every gunpowder operation within reach of New York and Philadelphia. He traveled, between February and August 1801, through the Brandywine Valley of northern Delaware. A corridor of approximately 15 miles of fast-moving creek, descending from the Pennsylvania line to the Christina River at Wilmington, lined with grist mills, paper mills, and small textile operations, all powered by the creek's reliable flow. He found, on the Brandywine 4 miles north of Wilmington, a 95-acre farm property owned by a Quaker landholder named Jacob Broom. The property had a fall of approximately 12 feet across a quarter-mile section of creek frontage. Sufficient hydraulic head to power the milling operations he had calculated would be necessary for industrial-scale powder production. He purchased the property in April 1802 for $6,740. He capitalized the operation through a partnership of family members, French émigré investors, and a single substantial American backer, Peter Baudy, a refugee planter from the French colony of Saint-Domingue. Total starting capital, $36,000. He began construction of the Eleutherian Mills powder, works on the 19th of July 1802. He completed the first operational mill house, a single granulation building, 2 press houses, a refinery, a charcoal kiln, and 3 storage magazines by April 1804. He produced his first commercial powder shipment on the 1st of May 1804. The powder was, by every contemporary test administered by United States Army quartermasters, between 1,804 and 1,812, the most consistent and most powerful black powder available from any American source. The U.S. Army awarded Eleuthère du Pont his first federal supply contract in 1811 for the production of artillery powder for the Springfield and Harper's Ferry arsenals. By the outbreak of the War of 1,812 inches June 1,812, Du Pont was the principal supplier of gunpowder to the United States Army. By the outbreak of the Civil War in April 1861, his sons and grandsons supplied by the U.S. War Department's procurement ledgers preserved in the National Archives approximately 55% of the total gunpowder consumed by the Union Army across the 4 years of the conflict. By 1880, the company had no significant domestic competitor. The operational consolidation of the modern DuPont company occurred between 1899 and 1917, under the direction of 3 of Eleuthère Irénée's great-grandsons, Pierre Samuel Dupont II, Thomas Coleman Dupont, and Alfred Irénée Dupont, known thereafter in family and corporate history as the Three Cousins. In February 1902, the Three Cousins collectively, the youngest active managers of the Brandywine Works, purchased the family company from the previous senior generation for $12 million in promissory notes. They incorporated it on the 24th of October 1903 as the modern A. DuPont de Nemours and Company. They acquired, between 1903 and 1907, approximately 65 smaller American powder and explosives manufacturers, including the principal competitors Laughlin and Rand, Hercules, and Atlas, consolidating 93% of the American explosives industry under DuPont control. In 1907, the United States Department of Justice filed an antitrust suit. In 1912, the federal court ordered the partial dissolution of the consolidated entity. Hercules and Atlas were spun out as separate companies. DuPont retained the core black powder, smokeless powder, dynamite, and military explosives operations. In December 1917, Pierre S. DuPont, by then president of DuPont, directed the company's accumulated wartime profits from World War I munitions sales into the purchase of approximately 23% of the common stock of General Motors Corporation. By 1920, DuPont's General Motors holding had increased to 36%. Pierre DuPont became chairman of the board of General Motors on the 16th of November of 1920. He retained both chairmanships, DuPont and General Motors, until his retirement from GM in 1929. The combined market capitalization of the two corporations at his retirement exceeded $1.5 billion. The DuPont family, in 1929, controlled the largest single integrated industrial enterprise on the North American continent. There is, in the operational history of every American Gilded Age dynasty, a single document that, read in retrospect, predicts the eventual catastrophe. For the Vanderbilts, it was the codicil of the 8th of November, 1876. For the DuPonts, it was the trust instrument executed by William DuPont Jr. and his wife Jean Liseter Austin DuPont in May 1965 in the law offices of the firm Richards, Layton and Finger in Wilmington, Delaware. The instrument established 4 equal trusts, one for each of the 4 children of the marriage. The trusts were funded by approximately $800 million in DuPont and General Motors stock divided in equal portions of approximately $200 million per heir. The four heirs were, in order of birth, John du Pont, born 1925, Henry E.I. du Pont, born 1929. William du Pont III, born 1931, and John du Pont, born the 22nd of November, 1938. By the Trust's operative paragraph 4c, each heir was to be granted, on his or her 21st birthday, full discretionary control over the income and the principal of the Trust, without prior consent or supervision by any trustee. There was no provision for the Trust's revocation in the event of the heir's incapacity. There was no provision for the appointment of a substitute trustee. There was no provision for the family review of the heir's expenditures. The youngest heir reached his 21st birthday on the 22nd of November 1959. In 7 years, John du Pont, at age 28, with no completed university degree, no formal business training, no operational role in DuPont or General Motors, no demonstrated commercial responsibility, will inherit, on the death of his mother, in March 1965, full discretionary control of approximately $200 million in trust assets. In 31 years, the same heir will, in a Pennsylvania driveway on the afternoon of the 26th of January 1996, fire 3 rounds from a revolver into the chest of an Olympic wrestler whose only documented offense, in the deteriorating internal logic of John du Pont's last 6 months, was that he had failed to confirm John du Pont's belief that the walls of John du Pont's mansion contained hidden tunnels through which his enemies were entering at night. All 3 sequences begin in the same place. The Trust Instrument of May 1965. Between November 1959 and approximately May 1986, John du Pont's biographical record reads, on its surface, as the eccentric but harmless leisure existence of a chemical industry heir with no operational role. He completed, after a decade-long undergraduate course punctuated by transfers between 3 institutions, a bachelor's degree in zoology from the University of Miami in 1965. He was, by the testimony of his graduate school faculty preserved in the Villanova University archives, an enthusiastic but academically marginal student. His subsequent doctoral degree from Villanova, awarded in 1973, was in natural science. The dissertation, a distributional atlas of birds in the Solomon Islands, was, by the dissertation committee's evaluation, primarily a compilation of field collection records with limited original analytical contribution. He spent the years between 1959 and 1976 collecting. He collected approximately 2,000 mounted specimens of birds and small mammals from the South Pacific. He collected approximately 2,500 American conchological specimens, primarily seashells. He collected approximately 300 firearms, organized by category in display cabinets across 2 ground floor rooms of the Foxcatcher Mansion. He collected, beginning in 1971, automobiles, primarily American post-war performance vehicles, displayed in a custom-built 6-bay garage adjacent to the main house. He attempted, between 1971 and 1981, to qualify for the United States Olympic team in modern pentathlon. He completed approximately 7 international competitions in the decade. His best documented finish was 21st at a 1976 International Invitational at Madison Square Garden. He did not qualify for the 1972, 1976, or 1980 U.S. Olympic teams. He did not, throughout this period, publish any operational comment on DuPont or General Motors. He did not attend the company's annual shareholder meetings. He did not vote his stock in any contested corporate proxy. He was, by every external measurement, the family member from whom no one expected anything operationally consequential. His mother, Jean Lissiter Austin du Pont, by the testimony of the long-serving Foxcatcher estate manager Daniel Chapman, given to the Pennsylvania State Police on January 27, 1996, described her youngest son in private as the one who would always need watching. She died on the 5th of August 1988 at age 91. The watching ended. The trigger event for the Foxcatcher catastrophe was not the murder of the 26th of January 1996. It was the September 1986 expansion of the wrestling program. The operational decision by John du Pont to convert his mother's 800-acre estate into the most heavily endowed private amateur wrestling facility in the United States. Du Pont had, beginning in approximately 1982, become interested in freestyle wrestling. He had hired, between 1983 and 1986, 3 successive head coaches for what he called Team Foxcatcher, initially a recreational program that paid stipends to a small number of college-level wrestlers in exchange for residence and training on the estate. The program, in its first 3 years, attracted approximately 12 athletes. The annual budget was approximately $200,000. In September 1986, 18 months before his mother's death, but at a moment when she was already in physical decline at age 89 and no longer effectively supervising the estate's expenditures, John du Pont commissioned the construction of a 14,000-square-foot training facility on the property. The facility, named the John du Pont International Training Center, opened on the 1st of June 1989. Its construction cost was approximately $14 million. He simultaneously announced the creation of Team Foxcatcher's Senior Elite Division, the program that would, over the next 7 years, recruit approximately 20 active United States Olympic-level freestyle wrestlers into permanent residence on the Foxcatcher estate. In December 1986, he hired the program's flagship recruit, Mark Schultz, the 1,984 Olympic gold medalist in freestyle wrestling at 82 kilograms, the brother of the future January 1996 victim, the author of the eventual 2014 memoir, Foxcatcher, on which the 2014 Steve Carell film was substantially based, accepted a 4-year contract to serve as the program's senior athlete and assistant coach. The contract paid Mark Schultz a base salary of approximately $53,000 per year, plus residence in a furnished cottage on the estate, plus full coverage of his international competition expenses, plus the use of a Foxcatcher-issued automobile. In November 1989, Mark's older brother David Schultz, the 1,984 Olympic gold medalist in freestyle wrestling at 74 kilograms, by every contemporary peer assessment, the most technically refined American wrestler of his generation, accepted a parallel contract. David Schultz moved into a small white frame house on the Foxcatcher access road with his wife Nancy and their 2 young children, Alexander, then 7, and Danielle, then 5. What no one in the Foxcatcher organization understood, in the autumn of 1989, was that the operational structure John du Pont had built a 800-acre private estate containing approximately 20 resident professional athletes who depended on him personally for their salaries, their housing, their competition funding, and their athletic program survival was the precise environment most likely to magnify the cognitive deterioration that was, by November 1986, already becoming visible to the residential staff in the form of repeated late-night accusations against household employees. The first sworn employee complaint against John du Pont, a discrimination action filed by the program's first assistant coach, Glenn Goodman, in November 1988, alleged that du Pont had ordered Goodman dismissed. Because, in du Pont's stated words to a witness, "I have determined that he is one of the people watching me through the walls." The complaint was settled out of court for approximately $90,000 in March 1989. It would not be the last. Between November 1988 and December 1995, John du Pont's documented mental deterioration progressed through approximately 4 operational phases. Each phase was witnessed by multiple Foxcatcher residents. Each phase was reported, in real time, to at least one external authority, a treating physician, a Pennsylvania State Social Services Agency, or a private security firm under contract to the estate. None of the reports produced an involuntary commitment, a removal of firearms, or a structural review of du Pont's discretionary access to the Foxcatcher Trust assets. The first phase between November 1988 and approximately spring 1991 was paranoid ideation focused on household staff. Du Pont accused, in this period, 3 successive estate housekeepers, 2 grounds maintenance workers, the chef of the residential kitchen, and the program's first assistant coach Glenn Goodman of conducting surveillance against him through concealed equipment in the walls. The employee turnover rate at Foxcatcher between 1988 and 1991, by the estate's payroll records preserved in the eventual 1997 trial discovery, was approximately 73% annually, roughly 6 times the comparable rate for a Pennsylvania residential estate of equivalent staffing. The second phase, between spring 1991 and autumn 1993, was the introduction of weapons into routine estate operations. Du Pont began, in this period, traveling around the 800-acre property in a tracked armored personnel carrier, a Chenoweth light strike vehicle he had personally purchased through a federally licensed surplus dealer in Texas in May 1991. He installed in the same period approximately 40 separate firearms in racks throughout the principal residence, the gymnasium, and the wrestler's cottage compound. He fired the weapons, by multiple sworn employee accounts, at random targets on the estate grounds, including, on one documented June 1992 occasion, at a vintage Lincoln Continental, he had personally driven into a pond on the property and decided he wanted to sink permanently. The third phase, between autumn 1993 and approximately summer 1995, was the elaboration of a delusional system in which Du Pont believed himself to be, simultaneously, the Dalai Lama, a Russian spy, and the last of the Christ-bearers. He instructed Mark Schultz, in February 1994, to address him exclusively as His Holiness. He told a Sports Illustrated reporter in May 1994, in an on-the-record interview, that he had personally placed listening devices in the Soviet embassy in Washington in the 1980s. The interview was published in the magazine's the 6th of June 1994 issue. It produced no public response from the United States government, the Soviet successor state, or any law enforcement agency. The fourth phase, between summer 1995 and the murder of the 26th of January 1996, was the active expulsion of long-tenured residents from the estate. Du Pont evicted Mark Schultz from the Foxcatcher program in July 1995, by Mark's own account, in Foxcatcher Negative 2014, after Du Pont had become convinced that Mark was conducting surveillance against him on behalf of the Bulgarian Wrestling Federation. Mark left the estate in late July 1995. He moved to Connecticut. His older brother, David Schultz, did not leave. David Schultz had, by that summer, 2 children in local Pennsylvania schools. His wife, Nancy, was substantially integrated into the Newtown Square community. He was 4 years and 11 months from his target retirement date as a competitive wrestler. He had concluded, by his own account in private correspondence with his brother Mark, preserved in Mark's 2014 memoir, that John du Pont's deterioration was real but manageable, that the Foxcatcher program would survive its founder's eccentricities until the 1996 Atlanta Olympics, and that he could complete the final 14 months of his own competitive career without operational disruption. He was, by every defensible retrospective measurement, wrong. The turning point, the precise, documented moment at which John du Pont's deterioration became, in the operational view of his treating clinicians, irreversible, occurred over a 48-hour period in late November 1995. On the afternoon of the 18th of November 1995, Du Pont attempted to drive his Lincoln Town car directly into the gymnasium of the John E. Point Du Pont International Training Center, while approximately 14 wrestlers, were in active practice on the mats. The doors of the facility were closed. He stopped the vehicle approximately 6 feet from the doors. He sat in the vehicle for approximately 12 minutes. He then reversed and drove back to the principal residence. That evening, the program's senior coach, a recently hired former Pennsylvania State University assistant named Valentin Jordanov, a Bulgarian Olympic medalist whom du Pont had personally recruited in 1994, telephoned du Pont's longtime treating psychiatrist, Dr. Philip Resnick, at his Cleveland clinic office. Resnick had treated du Pont intermittently since 1986. He had, by his testimony at the 1997 trial, attempted 3 separate involuntary commitment proceedings between 1992 and 1995. Each had been blocked by du Pont's personal attorneys. Resnick told Jordanov, by Jordanov's testimony at the trial, "He is past the point of voluntary management. The next event will be violent. There is nothing further any clinician can do without legal authority I have been unable to obtain." Jordanov did not relay the conversation to David Schultz. The reasons Jordanov gave at the trial, under cross-examination, were 3. He believed Resnick was being alarmist. He believed du Pont's eccentricities had been continuous since 1986, with no escalating violent component. And he believed any communication he made to Schultz about the call would result in du Pont's firing of Jordanov himself within 48 hours. David Schultz had 68 days left to live. In 68 days, on the afternoon of the 26th of January 1996, John du Pont will drive his Lincoln town car onto the gravel access drive in front of David Schultz's small white frame house at approximately 2:50 p.m. He will be wearing a red tracksuit. He will have a Smith & Wesson .44 Magnum revolver on his lap. The window of the car will be rolled down. In 69 days, by 9 a.m., on Saturday, the 27th of January 1996, the Pennsylvania State Police Special Emergency Response Team will have established a tactical perimeter around the principal residence at Foxcatcher Farm with 75 officers, 3 armored vehicles, 2 helicopters, and 1 direct telephone line connected to the residence's main switchboard. In 70 days, at 2:43 p.m., on Sunday the 28th of January 1996, John du Pont will walk out of the boiler room exterior door at the rear of the principal residence and will be arrested by Pennsylvania State Trooper Charles Reichel without incident. By 5 p.m. on the same Sunday, the most operationally catastrophic single act by a du Pont heir in the family's 208-year history will be complete. 3 of the 4 phases will, by retrospective forensic reconstruction, have been preventable. The instrument that prevented the prevention was the Trust Paragraph 4C of May 1965. To understand what happens on the afternoon of the 26th of January 1996, you have to understand a single architectural fact about the Foxcatcher estate. The estate consisted, by the Delaware County Tax Assessor's records of 1,995, of approximately 800 contiguous acres in Newtown Square, Pennsylvania. The principal residence, an Italianate masonry mansion of approximately 36 rooms across 3 floors, plus a basement service level, stood at the geographic center of the property, approximately 3/4 of a mile from the public road at every compass direction. The main entry drive ran for approximately 1¼ miles from Goshen Road on the south boundary, through 3 sets of automated gates, past the wrestling training facility, past a series of staff cottages, past the indoor swimming pavilion, and ended at the circular driveway in front of the principal residence. At a distance of approximately 400 yards from the principal residence, on a secondary access drive that branched eastward from the main drive, stood a modest 2-story white frame farmhouse. The farmhouse had been the original property's 19th-century manager's residence. It had been refurbished in 1989 for the use of the Foxcatcher senior athletes and their families. By January 1996, it was the residence of David Schultz, his wife Nancy, and their 2 children, by then ages 13 and 11. The driveway in front of the white frame house was unpaved gravel. It contained, on the afternoon of the 26th of January, 1996. 3 vehicles. One was Nancy Schultz's silver Toyota minivan, parked in the integrated garage. One was David Schultz's blue 1991 Subaru station wagon, parked in the driveway facing outward. One was a late-model dark sedan, owned by a Foxcatcher resident named Patrick Goodale, a Pennsylvania State Police firearms instructor whom du Pont had retained in approximately November 1995 as a private security consultant. Goodale was, on the afternoon of January 26, sitting in the driver's seat of John du Pont's 1995 Lincoln Town car, which had pulled up behind David Schultz's Subaru approximately 1 minute before the shooting. David Schultz was, at the moment du Pont's Lincoln pulled into the driveway, kneeling on the gravel between his own Subaru and the Foxcatcher security vehicle. He was attempting to install an aftermarket replacement radio in the Subaru. The temperature was approximately 28 degrees Fahrenheit. There was approximately 3 inches of dry snow on the surrounding grounds. There was no snow on the cleared driveway. Schultz was wearing jeans, a fleece jacket, and a wool watch cap. His wife Nancy was inside the house, in the kitchen at the rear of the ground floor, preparing dinner. His son Alexander was in the basement, working on a school project. His daughter Danielle was in the living room at the front of the house, watching television. The kitchen window faced the driveway. The living room window faced the driveway. Both children, at the moment of the events that followed, would be witnesses to what occurred. Both would, by their testimony to the Pennsylvania State Police on the evening of January 26, identify John du Pont's red tracksuit and confirm the sequence of 3 discrete gunshots. The Lincoln Town car arrived in the driveway at approximately 2:50 p.m. David Schultz stood up from his kneeling position beside the Subaru. He set down the screwdriver he had been using. He took approximately 3 steps toward the Lincoln. By the testimony of Patrick Goodale to the Pennsylvania State Police on the 27th of January, 1996, and by Goodale's testimony at the trial of January-February 1997, the following sequence then occurred over approximately 12 seconds. John du Pont, sitting in the driver's seat of the Lincoln, rolled down the driver's side window. He raised a Smith & Wesson Model 629, 44 Magnum revolver blued steel, 6-inch barrel, 6-round capacity that had been resting on his lap. He aimed the revolver through the open window at David Schultz, who was now standing approximately 3 feet from the driver's side door of the Lincoln. Du Pont's first audible statement, by Goodale's testimony, was a single sentence. "Do you have a problem with me?" David Schultz's response, by Goodale's reconstruction, was a single word, spoken in the rising intonation of a man who had not yet processed the visual fact of the firearm being aimed at his chest from 3 feet away. No? Du Pont fired the first round at approximately 2:51 p.m. The round entered David Schultz's right upper chest at the level of the 3rd rib, traveling at approximately 1,200 feet per second, and exited through the muscle of the upper back. Schultz stepped backward. Du Pont fired the second round approximately 2 seconds later. The round entered Schultz's left upper abdomen, traveling laterally, and lodged in the soft tissue of the right hip without exiting. Schultz fell to his hands and knees on the gravel. Du Pont opened the driver's side door of the Lincoln. He stepped out of the car. He walked around the open door. He stood approximately 2 feet from David Schultz, who was now lying on his right side on the gravel driveway, fully conscious, with both hands pressed against his abdomen. Schultz's last spoken sentence by Patrick Goodale's testimony was, "You don't have to do this." Du Pont fired the 3rd round at point-blank range into the center of David Schultz's back, between the shoulder blades, at approximately 2:53 p.m. The round transected the descending aorta. Schultz lost consciousness within approximately 15 seconds. He was pronounced dead at the scene by Newtown Square paramedics at 3:08 p.m. Patrick Goodale, by his testimony, did not draw his own service weapon during any of the 12 seconds. He had been retained, by his understanding of his consulting contract, as a firearms instruction and security systems consultant, not as an armed guard. He was not, by Pennsylvania law, authorized to discharge a private weapon in defense of a third party in the absence of an immediate threat to himself. He was, by his testimony, also clinically incapable of processing the visual information in front of him. That his employer had, in front of him, executed a man with whom he had been on cordial terms for 7 years, in the middle of the workday, in clear weather, on the employer's own property, for no operational reason that any subsequent investigator would ever fully establish. John du Pont returned to the Lincoln Town car at approximately 2:54 p.m. He drove back up the access drive toward the principal residence. He was inside the house by 2:58 p.m. He locked the doors. The standoff began. What happens between 2:54 p.m. on Friday, the 26th of January, 1996, and 2:43 p.m. on Sunday, January 28, 1996? The 47 hours and 49 minutes during which John du Pont was barricaded inside the principal residence at Foxcatcher is the longest barricade situation in the operational history of the Pennsylvania State Police as of that date. Patrick Goodale ran to the white frame house at approximately 2:55 p.m. He entered through the kitchen door. He told Nancy Schultz, who was at the kitchen sink, that her husband had been shot. Nancy Schultz ran out to the driveway. She knelt beside her husband. She held his head in her lap. She was, by every account given to the Pennsylvania State Police that evening, the first person to attempt cardiopulmonary resuscitation. She continued attempting CPR for approximately 6 minutes, until the first Newtown Square paramedic unit arrived at 3:01 p.m. The first 911 call from the Foxcatcher property reached the Delaware County Emergency Dispatch Center at 2:55 p.m. It was placed by Goodale from the kitchen telephone of the white frame house. The first Newtown Square Township police vehicle arrived at the property at 3 p.m. The first Pennsylvania State Police Trooper Michael Dengler of Troop K Media Barracks, arrived at 3:14 p.m. By 4:30 p.m., 95 minutes after the shooting, the Pennsylvania State Police Special Emergency Response Team had established a tactical perimeter at the Goshen Road south boundary of the property. Lieutenant Howard Kunkel of the CERT Command was on scene. He had been provided, by the surviving Foxcatcher residential staff, with the floor plans of the principal residence. He had identified by 5 p.m. the boiler room exterior door at the rear of the building as the most operationally accessible egress point. He had also been told by Goodale that the principal residence contained approximately 40 firearms in various racks, cabinets and concealed locations across the building's 3 floors. A military-grade tracked armored personnel carrier, the Chenoweth Light Strike vehicle, parked in the carriage barn approximately 70 yards from the house. An estimated 12,000 rounds of ammunition. 3 operational shortwave radio transmission units. And a basement-level vault containing, by Goodale's recollection, approximately 200 additional firearms and an unknown quantity of military-grade explosives. The fact in the last item, the basement vault, was not confirmed during the standoff. It was confirmed after the surrender by the Pennsylvania State Police Evidence Recovery Team that searched the residence between January 28 and the 4th of February, 1996. The vault contained 157 additional firearms. It did not contain explosives. The original mistaken belief was the operational reason the CERT Command did not breach the residence at any point during the 47-hour standoff. There was no cover-up of what happened at Foxcatcher. There was, simply, an operational containment that the Pennsylvania State Police executed with uncharacteristic patience because the family of the suspect had, within 90 minutes of the shooting, retained the most operationally credible criminal defense attorney in the Philadelphia bar. The attorney was Richard A. Sprague, by January 1996, the most prominent trial lawyer in Pennsylvania, the former first assistant district attorney of Philadelphia, the lead prosecutor in the Yablonsky Union murder case, the personal attorney to multiple sitting United States senators. Sprague was retained by John du Pont's surviving brother William du Pont III at approximately 4:30 p.m. on the afternoon of the 26th of January, 1996. By 5:15 p.m., Sprague had spoken by telephone to Lieutenant Howard Kunkel of the CERT Command at the perimeter. By 6 p.m., the operational protocol of the standoff had been agreed. The protocol had 3 terms. First, no breach of the residence would be attempted unless du Pont initiated active fire from inside. Second, no telephone communication would be attempted with du Pont after 9 p.m. on any of the standoff days. Third, the operational pressure for surrender would be applied through the residence's environmental systems rather than through direct tactical engagement. The third term was the operational decision that ended the standoff. By 6 a.m. on Sunday, the 28th of January, 1996, approximately 39 hours into the standoff, the CERT command had cut the electrical power to the principal residence. By 8 a.m., the residence's gas-fired central heating system had failed. By noon, the interior temperature of the residence had fallen to approximately 40 degrees Fahrenheit. By 2 p.m., it had fallen below freezing in the upper floor rooms. John du Pont, by the recovered residence thermostat records and by his own subsequent statements to the Pennsylvania State Police on the evening of his arrest, attempted between approximately 6 a.m. and 2 p.m. on Sunday to ignite 3 separate fires in the residence's first-floor fireplaces using newspaper, books, and an unknown quantity of furniture, timber. None of the fires sustained. The principal residence's chimneys had been closed by CERT personnel at approximately 5:30 a.m. He emerged from the boiler room exterior door at 2:43 p.m. on Sunday, the 28th of January, 1996. He was wearing a heavy wool overcoat over the same red tracksuit he had been wearing on Friday afternoon. He was unarmed. He surrendered without verbal incident to Pennsylvania State Trooper Charles Reichel. He was transported by 3:30 p.m. to the Newtown Square Police Station, and from there, at 5 p.m., to the Delaware County Prison in Thornton, Pennsylvania. The arrest produced, in the Philadelphia Inquirer of the 29th of January 1996, the headline that would define the case in the American press for the next 13 months. America's richest murderer. The fallout from the arrest, in the immediate days that followed, was concentrated in 3 places. In the white frame house at Foxcatcher, Nancy Schultz, 36 years old, the widow of approximately 52 hours, the mother of 2 children who had witnessed their father's murder from interior windows, began the practical work of removing the family from the property. She and the children were out of the house, by Mark Schultz's account in Foxcatcher -2014, by the morning of the 2nd of February, 1996. They moved to a small house in the Stevens Point area of Wisconsin. Nancy Schultz did not return to Pennsylvania for any purpose until the trial of January 1997. In the offices of E.I. du Pont de Nemours and Company in Wilmington, Delaware, the Corporate Communications Office issued, on the morning of the 29th of January 1996, a single paragraph and public statement. The statement noted that John E. du Pont was a private individual with no operational role in the company, and that the company extends its sympathy to the family of David Schultz. The corporate statement, by the Count of Gerard Colby in Du Pont Dynasty, Behind the Nylon Curtain, revised 1984 edition, was the only public communication issued by the corporation regarding any individual Du Pont family member during the entire decade of the 1990s. In the Delaware County District Attorney's Office, the case was assigned to First Assistant District Attorney Joseph McGettigan III on the afternoon of the 29th of January 1996. McGettigan would, by his own subsequent account, spend the next 13 months preparing a single defendant criminal prosecution against the most heavily defended individual defendant in the modern history of the Pennsylvania criminal courts. Commonwealth of Pennsylvania v. John E. du Pont, Criminal Docket CP2 3CR0006 981996 was tried before Judge Patricia Jenkins in the Court of Common Pleas of Delaware County, Pennsylvania, between January 21 and the 25th of February, 1997. The 13 months between the arrest of the 28th of January 1996 and the start of testimony on the 21st of January 1997 were dominated by a single procedural question. Was John E. du Pont by Pennsylvania law, mentally competent to stand trial? The question was litigated through 3 separate competency hearings. Each hearing involved expert testimony from at least 2 psychiatrists for the prosecution and at least 2 for the defense. The first hearing, in May 1996, found du Pont incompetent. He was committed to Norristown State Hospital, a Pennsylvania state psychiatric facility for involuntary treatment. The treatment consisted, by the published clinical record, primarily of olanzapine and clozapine second-generation antipsychotic medications. The second hearing, in September 1996, found du Pont restored to competency. The defense appealed. The appeal was denied. The third hearing, in December 1996, confirmed the September finding. The trial was scheduled for the 21st of January 1997. The defense theory at trial was insanity. The defense did not contest the physical elements of the killing. Richard Sprague conceded, in his opening statement on the 22nd of January 1997, that John du Pont had fired the 3 rounds from the .44 Magnum revolver, and that those rounds had caused David Schultz's death. The defense theory was that du Pont had been, at the moment of the shooting, in the active grip of a paranoid schizophrenic delusional system that rendered him operationally incapable of distinguishing right from wrong by the legal standards set in Pennsylvania case law. The prosecution theory was that du Pont's mental illness, while real and severe, did not meet the Pennsylvania insanity threshold. The prosecution argued, through 23 witnesses across 18 days of trial, that du Pont had, in the 12 seconds of the shooting itself, exhibited operationally rational behavior, selecting his target, articulating a verbal confrontation, firing accurately at the body's vital region, and walking around to administer the 3rd round at point-blank range that contradicted the legal claim of incapacity. The jury was empaneled on the 21st of January, 1997. It consisted of 7 women and 5 men, drawn from the Delaware County jury pool. The jury heard testimony for 36 trial days. It heard closing arguments on the 19th of February, 1997. It began deliberating at 11:30 a.m. that morning. It returned its verdict on the 25th of February, 1997, at approximately 4:30 p.m., after 55 hours of deliberation across 7 days. The verdict, when foreperson Daniel Lent read it in the open courtroom on the afternoon of the 25th of February 1997, was a Pennsylvania verdict that did not exist in any other state of the Union. The jury found John Eleuthère du Pont guilty of the count of murder in the 3rd degree. It found him, simultaneously, mentally ill at the time of the act. By Pennsylvania statute, specifically 18 Pascals, CS, Section 314, the guilty but mentally ill provision, the verdict required the court to impose criminal sentence consistent with the underlying conviction, while mandating that the sentence be served in a facility capable of providing continuous psychiatric treatment. The verdict was, by every contemporary assessment in the Pennsylvania criminal defense bar, the operational compromise the jury had reached on the question of whether to substantively excuse the conduct of an heir whose entire adult life had been a documented descent into delusional psychosis. They did not excuse him. They also did not pretend the killing had been the rational act of a competent man. They split the verdict. Judge Jenkins imposed sentence on the 13th of May 1997. John du Pont received 13 to 30 years in Pennsylvania State Prison. He was credited with the 471 days he had already served at Norristown State Hospital. His earliest parole eligibility date was the 29th of January 2009. His maximum statutory release date was the 29th of January 2026. He served his sentence at the Pennsylvania State Correctional Institution at Mercer, Pennsylvania, from May 1997 through October 2008, and at the State Correctional Institution at Laurel Highlands, a medical needs and mental health specialized facility in Somerset County, from October 2008 until his death. In May 2009, 3 months after his earliest parole eligibility date, John du Pont applied for parole. The application was denied by the Pennsylvania Board of Probation and Parole on the 18th of August, 2009. The board's decision noted, in its single-paragraph published rationale, the applicant has not, in the 11 years he has been incarcerated, expressed sustained remorse for the killing of David Schultz, has not consistently complied with prescribed psychiatric medication regimens, and has not, in the operational view of his treating clinical staff, achieved a level of mental status improvement that would render him an acceptable candidate for community supervision at this time. He did not reapply. He died at SCI Laurel Highlands on the morning of the 9th of December 2010 at the age of 72. The cause of death, by the Pennsylvania State Department of Corrections public statement of December 9, was complications of chronic obstructive pulmonary disease. He had been a heavy cigarette smoker for approximately 52 years. He left, by the will he had executed in approximately 1985, and that had not been substantively modified during the 14 years of his imprisonment, an estate of approximately $72 million in residual trust assets. The depleted remainder of the original $200 million 1,965 trust principal, after the payment of the approximately $14 million in defense fees, the wrongful death settlement to Nancy Schultz of approximately $35 million, paid in 1996, and the operational drawdown of the Foxcatcher estate's expenses across the period of his incarceration. The principal beneficiary of the will, by its operative paragraph, was Valentin Jordanov, the Bulgarian Olympic medalist who had been the program's senior coach in November 1995, who had not relayed Dr. Resnick's warning to David Schultz, and who had remained, throughout John du Pont's incarceration, the single most loyal of his former associates. Jordanov inherited approximately 80% of the residual estate. The 800-acre Foxcatcher estate was sold by John du Pont's estate in two principal parcels between 2011 and 2013. The first parcel, approximately 320 acres, including the principal residence and the original wrestling training facility, was sold in November 2011 to a real estate investment partnership for approximately $15 million. The principal residence was demolished in March 2013. The site was redeveloped between 2013 and 2018 as a housing subdivision named Lisiter, the developer's commemorative reference to John du Pont's mother, Jean Lisiter Austin du Pont. The subdivision contains, by its 2026 marketing materials, approximately 350 single-family residences priced between $1.5 and $4 million each. The second parcel, approximately 480 acres of the original property's wooded buffer and pasture, was sold in March 2013 to the Natural Lands Trust, a Pennsylvania conservation organization, for approximately $11 million. The land was reopened to the public in 2017 as the Sawmill Park Preserve. The wrestling training facility, the John E. du Pont International Training Center, the 14,000-square-foot building that had opened on the 1st of June 1989, that had hosted approximately 20 resident senior athletes between 1,989 and 1,996, that had produced 4 1,996 United States Olympic medalists across freestyle and Greco-Roman wrestling, was demolished in October 2013. The white frame house in which David Schultz had lived between November 1989 and his death on the 26th of January 1996, and the gravel driveway in front of it, were preserved during the 2013 demolition by the Lisiter developer's instruction. They are, in 2026, the location of the entry guardhouse of the Lisiter subdivision. There is no plaque on the guardhouse. There is no historical marker at the Foxcatcher entrance gate on Goshen Road. The Pennsylvania Historical and Museum Commission has, by the records publicly accessible through its 2024 annual report, declined 3 separate applications for the placement of a Schultz memorial marker on or near the property. The basis for each declination, by the Commission's published rationale, has been that the events of the 26th of January 1996 are not of historical significance to the Commonwealth of Pennsylvania. Mark Schultz, David's brother, the 1984 Olympic gold medalist, the author of the 2014 memoir Foxcatcher, has, by his public statements between 2014 and 2024, attended one annual private memorial gathering at the Lisseter Guardhouse on each anniversary of his brother's death. The gathering is attended, in 2026, by approximately 14 people, including Nancy Schultz and the two adult Schultz children, Alexander, now 43, and Danielle, now 41. It is the only continuous public commemoration of David Schultz's death. The du Pont Company at John Eleuthère du Pont's birth in 1938 had a market capitalization of approximately $410 million and approximately 78,000 employees worldwide. The Du Pont Company at his death in 2010, by then a substantially restructured global chemical and agricultural enterprise, had a market capitalization of approximately $44 billion and approximately 60,000 employees. The company survived the 1996 catastrophe of its founder's great-great-great-grandson without any material operational consequence. The family survived without any material operational consequence. The fortune survived without any material operational consequence. The two operational casualties were David Leslie Schultz, age 36, freestyle wrestler, husband, father of two, and the structural integrity of every American family trust instrument that has, since February 1997, been written without a paragraph 4C supervisory clause. The May 1965 Trust paragraph 4C is in the Trusts and Estates literature of the modern American Legal Academy, taught as the canonical example of what not to do. It is in 2026 called the Du Pont Clause. 6 generations. One French émigré builds, one son industrializes, 3 cousins corporatize, 1 generation philanthropizes, 1 generation diversifies, and 1 heir, in the 7th generation expression of a fortune that had survived every prior failure mode, kills. The Du Pont pattern is not the Vanderbilt pattern of architectural display. The Du Ponts did not build 70-room marble cottages. The principal family residences, Winterthur, Longwood Gardens, Nemours, Hagley, Granog, were operational country estates that converted, in every documented case across the family's 224-year history, into either public museums, public gardens, or family foundation-owned cultural assets. By the count of the Hagley Museum's 2024 archival inventory, 11 separate Du Pont family residences are open to the paying public in 2026. None of them, including Foxcatcher, is in private family hands. The Du Pont pattern is also not the Astor pattern of expatriation. No Du Pont of any generation renounced American citizenship. No principal Du Pont branch relocated its operational headquarters outside the Brandywine Valley of northern Delaware. The family remains, in 2026, the single largest private landowner in the state of Delaware. The Du Pont pattern is also not the Vanderbilt pattern of dispersion through equal division among many heirs. The 1965 trust instrument that funded John Eleuthère du Pont's $200 million discretionary inheritance was one of approximately 340 separate Du Pont family trust instruments, operational in 1996, by the conservative count in Colby's Du Pont Dynasty, negative 1984 revised edition. The family had, by 1965, perfected the operational discipline that the Vanderbilts had failed to achieve in 1885. The fortune was not divided into one piece per heir. It was distributed across a deliberately constructed multi-generational system of separate trusts, separate trustees, separate disbursement schedules, and separate operational oversights. The Du Pont pattern is its own pattern. It is the pattern of the single defective trust instrument inside an otherwise operationally disciplined system. What does the story of the Du Pont family ultimately mean? It means first that the operational discipline of a family trust system is only as strong as its most permissive single instrument. The May 1965 trust instrument that William Du Pont Jr. and Jean Lisseter Austin Du Pont, executed for their 4 children, was by every comparative measurement against the prior 2 centuries of du Pont family trust, drafting the structurally weakest single instrument the family had ever produced. Its paragraph 4C granted full discretionary control of $200 million to a 21-year-old heir without a single supervisory clause. The other, approximately 339 du Pont family trusts operational in 1996, contained on average between 3 and 7 separate supervisory clauses each. The 1965 instrument was the one defective unit inside an otherwise functional system. The defective unit produced the catastrophe. It means, second, that mental illness in a family of substantial inherited wealth, in the absence of legal mechanisms for involuntary intervention, is operationally indistinguishable from sovereignty. John du Pont's mental deterioration was witnessed in real time, beginning in November 1986, by no fewer than 14 documented external observers, physicians, psychiatrists, employees, journalists, county social services workers. Each observer, individually, made the same operational determination: that the heir's behavior, while concerning, did not meet the legal threshold for involuntary commitment, and that the heir's personal attorneys would, in any event, contest such a commitment with operational resources greater than the resources available to the petitioner. The aggregate effect across 9 years was that no intervention occurred. The aggregate effect on the 26th of January, 1996, was that David Schultz died. And it means, third, that the operational permissions that flow from a defective trust instrument are not always financial. They are, in the most catastrophic individual cases, behavioral. John du Pont did not spend his $200 million in any operationally extravagant way. He spent it on a wrestling program, an academic facility, an athletic foundation, and approximately 400 firearms. He did not, by any defensible accounting, deplete his trust principle. He depleted, instead, the structural protection that should have prevented the trust principle from financing the gradual construction of an environment, the 800-acre fortified private estate, the resident athletes who depended on him personally, the absent supervisory authority in which his deterioration could proceed for 9 years without external interruption. This is the du Pont pattern. It is not the failure of a fortune, it is the failure of a single supervisory clause. The fortune is intact in 2026. The clause has been corrected in every comparable family trust instrument written since February 1997. The casualty is buried in Palmyra, Wisconsin, in the cemetery of the Pleasant Valley Lutheran Church. He was 36 years old. Drive west from central Philadelphia on Westchester Pike, cross the city boundary into Delaware County, continue past the Newtown Square Town Center. At the corner of Westchester Pike and Goshen Road, turn south. Drive approximately 1¼ miles. On the east side of Goshen Road, set back from the road behind a modest brick and iron entrance sign reading, "Lizeter, a Toll Brothers Community," you will see a guardhouse. The guardhouse stands on a paved circular driveway that did not exist in 1996. Behind the guardhouse, at a distance of approximately 400 yards, on a grassy cul-de-sac that occupies the precise footprint of what was, on the afternoon of the 26th of January 1996, the gravel access drive in front of David Schultz's residence, are 7 single-family houses of approximately 5,000 square feet each, constructed by Toll Brothers between 2014 and 2017. The houses are priced, by the 2026 multiple listing service records, between $2,200,000 and $3,100,000 each. The yards are landscaped. The driveways are paved. The mailboxes are uniform. There is no plaque. There is no historical marker. There is, on the small landscaped island in the center of the cul-de-sac, a single decorative stone, a piece of weathered Pennsylvania fieldstone, approximately 18 inches across, that the Lizeter developer placed during the 2014 site grading work. The stone has no inscription. It is a landscape feature. It is the only physical object in the cul-de-sac that was present on the property in 1996. The cul-de-sac, by the Toll Brothers Community Design Plan, is named Schultz Court. The street name was, by the developer's published 2014 explanation, selected from a list of historically significant Delaware County figures, with no specific reference intended. The 7 families who, in 2026, live on Schultz Court are not, by the developer's resident records, related to the Schultz family of Wisconsin in any documented way. The Schultz family has not, by Mark Schultz's public statements, ever requested the removal of the street name. It remains. So we return, one final time, to the question we asked in the cold open. How does an American family that began with a single French émigré chemist setting up a gunpowder mill on the banks of the Brandywine Creek in 1802, the family that supplied half of the gunpowder used by the Union Army in the Fouls Civil War, that controlled the largest chemical company in the world, that produced nylon, neoprene, Kevlar, Lycra, Teflon, and the synthetic explosives used in the Manhattan Project end, after 194 years of unbroken commercial succession, with the founder's great-great-great-grandson firing 3 rounds from a revolver into an Olympic wrestler in a Pennsylvania driveway? The answer is that the family did not end. The fortune did not end. The chemical company did not end. The General Motors investment did not end. The approximately 340 other Du Pont family trust instruments did not end. What ended was a single Olympic wrestler's life. What was permanently corrected was a single supervisory clause in the standard form of American family trust drafting. The Du Pont catastrophe was not a dynasty collapse. It was the price one family paid, and that one specific man paid in full for the operational lesson that an unsupervised trust principle, in the wrong hands, in the wrong decade, in the wrong cognitive state, is not capital. It is a weapon. The red tracksuit, the Smith & Wesson, .44 Magnum revolver, the 1995 Lincoln Town Car, with the driver's side window rolled down in a Pennsylvania driveway, on the afternoon of the 26th of January, 1996. The May 1965 trust instrument, with the paragraph 4C discretionary clause that taught the modern American Trusts and Estates Academy what not to do. The November 1986 first paranoid episode, the November 1988 Glenn Goodman complaint, the November 1995 attempted drive into the gymnasium, the November 1995 Resnick warning that did not reach David Schultz. The 4 November moments, across 9 years, that each could have prevented the afternoon of January 26, 3 documents, 3 firearms, 3 rounds. One 36-year-old man kneeling in a Pennsylvania driveway, repairing the radio of his Subaru on the afternoon of a Friday in late January, 15 minutes from his last full breath. In each case, the Du Pont fortune was operationally present at the moment of the catastrophe. In each case, the fortune did not cause the catastrophe. The choice to fund a trust without supervision caused the catastrophe. The distinction is the entire thesis of this video. David Leslie Schultz is buried at the Pleasant Valley Lutheran Church Cemetery in Palmyra, Wisconsin. His headstone reads, David Leslie Schultz, the 6th of June 1959, the 26th of January 1996, Olympic champion, beloved husband and father. John Eleuthère du Pont is buried in the family cemetery on the grounds of the Sand Hole Woods at the original Eleutherian Mills property in Greenville, Delaware, the cemetery in which Eleuthère Irénée du Pont himself was buried in 1834. The cemetery is approximately 23 miles by road from the Liciter Guardhouse on Goshen Road. The two locations are connected, in 2026, by no historical marker, no commemorative road sign, and no public commemoration of any kind. The fortune continues. The line continues. It is, finally, just a family. On the afternoon of Friday, the 26th of January 1996, at approximately 2:50 p.m., on a gravel-access driveway leading to a small white frame house on an 800-acre private estate in Newtown Square, Pennsylvania, 23 miles west of central Philadelphia. A 1995 Lincoln Town car pulled to a stop in front of an Olympic gold medal wrestler who was kneeling on the driveway repairing the radio of his Subaru. The driver of the Lincoln rolled down the driver's side window. The wrestler stood up and walked toward the car. The driver raised a Smith & Wesson .44 Magnum revolver, asked, "Do you have a problem with me?" and fired 3 rounds into the wrestler's chest, abdomen, and back. The wrestler's name was David Leslie Schultz. He was 36 years old. He was the 1984 Olympic gold medalist in freestyle wrestling at 74 kilograms. He was, at the moment of his death 15 minutes later, the head coach of one of the United States' primary Olympic training facilities for the 1996 Atlanta Games. The driver of the Lincoln was John du Pont, 57 years old, the great-great-grandson of Eleuthère Irénée du Pont de Nemours, the French chemist who had founded the DuPont gunpowder mill on the Brandywine Creek in 1802. He was, by the trust instruments executed in his mother's will of 1965, the heir to approximately $200 million in DuPont and General Motors stock. This is the full story of the DuPont dynasty from the morning of the 1st of January 1800. When a French émigré chemistry apprentice trained personally by Antoine Lavoisier walked off the merchant ship American Eagle at Newport, Rhode Island, carrying a letter of introduction from Thomas Jefferson, to the afternoon of the 9th of December 2010, when his great-great-great-grandson died in his cell at the Pennsylvania State Correctional Institution at Laurel Highlands. We trace every documented decision. The founding of the Eleutherian Mills powder works on the Brandywine on the 19th of July, 1802. The 1903 incorporation of the modern DuPont Company by the 3 cousins Pierre, Coleman, and Alfred. The December 1917 acquisition of a controlling interest in General Motors. The May 1965 trust instrument, with the paragraph 4C discretionary clause that taught the modern American Trusts and Estates Academy what not to do. The September 1986 expansion of the Foxcatcher wrestling program. The November 1995 Resnick warning that did not reach David Schultz. The 12 seconds of the shooting itself. The 47-hour standoff that ended at 2:43 p.m. On Sunday, the 28th of January, 1996, the trial. The verdict of guilty but mentally ill on the 25th of February, 1997. The prison years, and the demolition of the Foxcatcher mansion in March 2013. The thesis is not that the DuPonts lost their fortune. The fortune is intact in 2026. The chemical company is intact. The General Motors investment is intact. The approximately 340 other DuPont family trust instruments are intact. What collapsed was a single supervisory clause in a single trust instrument. And what that single clause produced across 31 years and 1 Pennsylvania driveway was the most operationally catastrophic single act by an American chemical industry heir in the family's 208-year history. The May 1965 Trust Paragraph 4C is in the Trusts and Estates literature of the modern American Legal Academy, taught as the canonical example of what not to do. It is, in 2026, called the DuPont Clause. Every name, date, dollar figure, and quoted line in this documentary is sourced. Full bibliography in the comments.